All right, all right, all right. So, with no further ado, we're going to pop this one off. This is the next episode in a series. I'm going to title them properly, I believe, at some point. But this is the second episode in a series. That last episode was business associations. It was just an introduction and an overview. But I'm going to touch briefly on the entity. All right. So let's jump right into it. No delays. And what is an entity? An entity is anyone or anything that the law recognizes as a legal actor. In addition to natural persons, which are human beings, entities include corporations, partnerships, LLCs, trusts, estates, associations, nonprofit corporations, benefit corporations, co ops, governments, government agencies, and numerous others, utility authorities, utility agencies as well. All right. So when a natural person owns a business, the business is referred to as a sole proprietorship. Let me repeat that. When a natural person like you and me, flesh and blood, owns a business, the business is referred to as a sole prop. The natural person will probably maintain a strict separation of the person's business and personal financial affairs through both record keeping and physical segregation. Now, that's an important practice to utilize whether you're a sole proprietorship, corporation, S corp, partnership, no matter what form of business that you're doing. It's always in your best interest, but especially if you're a legal entity. Sole prop it's not really required, but I would get in the habit of following that protocol anyway, because you never know when you're gonna flip the switch, when you're gonna form a legal entity, and you'll already be in the habit of separating your business and your personal. And it gets really, really important once you step into the arena of dealing with legal entities. All right. So the natural person will probably maintain a strict separation of the person's business and personal financial affairs, again, through both record keeping and physical segregation. That may enable the person to sell or transfer the business as if it were owned by a separate entity. As noted, however, a business is not an entity. The distinguishing characteristics of an entity are that it can own property, owe debts, enter into contracts, sue, and be sued, just like you and I, just like me and you. In the eyes of the law, a business can do none of those things. The business owner, whether a natural person or an artificial entity, can. An artificial entity is an entity that is not a natural person, like a LLC, like a C corporation. And if you go down that dumb road, even the S corporation, I do not favor the S corporation at all. You will always hear me tout, promote the C corporation, most importantly, the LLC that has elected to be taxed as a C corporation. That's what I promote. All right. As the Supreme Court said of the corporation that owned Dartmouth College in Trustees of Dartmouth College versus Woodward, 17 U.S. 518-636 in 1819, a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. In most circumstances, the law treats artificial entities as persons, separate and distinct from the people who participate in them. As a person, an entity owns its property and owes its own obligations. Again, an entity. All right, that's going to be your C corporation or the natural person. The S corporation does not come into play because the S corporation is a pass through entity and all income is passed through from that's made through the company passed down through to the individual. So the individual there is the person. And also, excuse me, the corporation, the C corporation, can own the business. All right. So the law will treat the C corporation as persons separate and distinct from the people who participate in them. Again, as a person, an entity owns its own property and owes its own obligations. All right. So we're going to dive in and we're going to talk about entity types. We're going to talk about terminologies. I'm going to give y'all a little game on on the terminology, because again, you have to be able to understand what's being said to you, and you have to make sense when you're saying things when it comes down to business and dealing with entities. All right, so each type of entity is governed by a separate statute or law. That is, each state has a corporation law that governs corporations, a partnership law that governs partnerships, and an LLC law that governs LLCs, and a limited partnership law that governs limited partnerships. All right, so throughout all of these episodes, all right, we're going to reference two corporation statutes. All right, and most every state follow these two corporate statutes, and that the first one is the Delaware General Corporation Law of 2020, also known as the DGCL, and the Model Business Corporation Act of 2016, also known as MBCA. All right, and some other laws that we will tap into is the Revised Uniform Partnership Act of 2013, also the Uniform Limited Liability Company Act of 2013, and the Uniform Limited Partnership Act of 2013. These four types of entities function in essentially the same way. The investor transfer money, property, or services to the entity in exchange for investment rights. The investment rights are specified in fundamental documents, such as the operating agreement, that contain the agreements among the investors and the entities. Those fundamental documents provide how and when decisions will be made and profits will be shared. All right. The fundamental documents are very key and paramount when you're forming a C corporation or when you're forming an LLC that has elected to be taxed as a C corporation. The operating agreement trumps the law. So the law is the default. So if you don't have an operating agreement, then you have to abide by the laws. But you're entitled to run your business however you want to run your business. You just have to make sure you have it drawn up in the operating agreement and also that it's legal. All right. But these laws, these LLC laws and corporation laws and all of those things, they're the default standard. You can, twerk around a lot of those laws, a lot of the provisions in the law by adding your own provisions in your operating agreement. Your operating agreement is the Bible for your company, people. All right, so make sure you get a good solid one when you do that. All right. So despite the functional equivalence of these entities, each entity type comes with its own terminology. All right. So let me back up real quick. So to repeat that last sentence that I was going over, we was talking about the investors transfer the four entity types, the four entity functions, they all function in essentially the same way. Investors transfer the money, property, or services to the entity in exchange for investment rights. The investment rights are specified in the fundamental documents that contain the agreements among the investors and the entities. Those fundamental documents provide how and when decisions will be made and profits will be shared. Now, the investors themselves may make decisions, you know, the investors themselves may make the decisions. They can elect managers to make some or all of the decisions, or the fundamental documents may appoint such managers. So, despite the functional equivalence of all four entities, each entity type comes with its own terminology. All right. So, investors in corporations are called shareholders or stockholders, while investors in LLCs are called members. Investors in partnerships are called partners, and investors in limited partnerships are called general partners or limited partners. The investment rights are referred to as shares or stock when the entity is a corporation, interests when the entity is an LLC or partnership, and interests or units when the entity is a limited partnership. Any of these investment rights may be referred to as shares. All right. The fundamental documents for a corporation are called articles of incorporation and bylaws. In Delaware, the articles of incorporation are called the certificate of incorporation. For an LLC, the corresponding documents are the certificate of organization and operating agreement. For a limited partnership, it is the certificate of limited partnership and partnership agreement. For each of those entities, the first of the two documents is filed with the state to create the entity. The second is held by the entity and its investors because partnerships are not created by filings with the state. They have only one fundamental document, which is the partnership agreement. All right, so we're going to talk about shares briefly. Shares are basically contract rights entitling the investors to participate in the entity's decision making in specified ways, to receive distributions of money or property from the entity in specified circumstances or both. For example, shares of stock typically entitle shareholders to vote on the election of directors and to receive dividends when the entities pay them. Shares may or may not be freely transferable. And let me stop for 1 minute just so I can kind of chime in because I don't want to lose nobody early on. Now, like for example, when I was just going over about the shares, right? The the terminology that I'm using and the way I'm speaking is as if this would be, Coca-Cola or Best Buy with a big board and, and a bunch of members and all of that. Remember what I told you. One individual can do this exact same thing. So, when I talk about investors participating in the entity's decision making, if it's just you and you're solo dolo and you have elected your LLC to be taxed as a C corporation, you still you're not required by law to follow the formalities of the C corporation, but it's in your best interest to follow the formalities of the C corporation because you're being taxed as a C corporation. You get all the rights and benefits of those that are, that have set up a C corporation outright. It's the same difference. No difference. Basically the same thing. The LLC laws are a lot more laxed. You don't have to have a board, you don't have to have the meetings and all of those things. But if you elect to be taxed as a C corporation, you need to do all of those things. And you may say, well, LLC boss, how do I have a meeting and it's just me? You have a meeting with yourself. Sounds weird, but it's true. And it's the law. You have that meeting with yourself. Whatever decisions you make, you're having that meeting with yourself. You document those minutes on who attended the meeting and the whole 9 yards. You do it the same way. You just do it solo dolo. It's just you and yourself having a meeting. All right. Minutes are easy to keep. And at some point throughout all of these episodes that's coming up, we're going to get down to all of that as well. Just keep following, keep listening, and pay attention. Investors have three options for managing their entity. All right. They have three options. They can manage in their capacities as investors. They can manage in their capacities as managers, or they can elect professional managers, right? So, regardless of the option chosen, persons acting in the capacities of officers, agents, or employees will implement the manager's decisions. When investors manage in their capacities as investors, the arrangement is called shareholder management in a corporation and member management in an LLC. The shareholders or members don't hire anyone to manage for them or conjure up new titles for themselves. They just meet and decide. Perhaps because managing in the capacity of investor is so common in partnerships and limited partnerships, it has no name. Investors or others who work in the capacity of managers are called the board of directors in a corporation, the managers in an LLC, and usually the managing partners or the executive committee in a partnership. General partners manage limited partnerships. And so that we don't lose track of where we are and what we're doing, we're just going over some of the terminology um, that's used throughout the legal entity area, right? Or the legal entity field. And when dealing with corporations, LLCs, limited partnerships, etc., those things that I mentioned previously, all right? So, for a combination of ideological and historical reasons, American entity laws impose few requirements on the entities, their investors, or their managers. Instead, the statutes state what appear to be requirements but qualify them as applying only if the contract among the participants does not provide otherwise. And that's that thing that I was telling you earlier about the law being default, because your companies, you can govern your company however you choose to govern it, as long as you have an agreement between you and your other partners. And if it's just, if you solo dolo, if you have that understanding with yourself. And it's always best to put this through one of the fundamental documents, whether you have a corporation or the LLC that's elected to be taxed as a C corporation. All right, and for that, that would be the operating agreement. All right. Okay, so the result of the whole thing is that the entity laws operate in a manner fundamentally different from other statutes. When contracts conflict with entity, when contracts conflict with entity statutes, it is usually the contracts that prevail. So what do I mean? If you enter into a contract, you got your operating agreement that states something, and you got it all worded up in your contract how you want it to be and how you want to run it. That typically is going to prevail or going to override um, the law, the statutory provisions that are typically the default rules, like I mentioned. Now, the policy for permitting override is to encourage private ordering. Private ordering extends to almost every salient feature of American entity types. The default rule is that a corporation is governed by a board of directors, but a corporation can be governed by anyone or anything it chooses, including shareholders, a manager, another artificial entity, or even kings and queens. Partnerships and LLCs, sometimes called the investments they issue shares, and corporations are free to call the investments they issue interests or units. Among themselves, the rights of investors, managers, and officers can be whatever the parties agree, almost regardless of the entity type involved. All right. Now, although the parties could override most of entity law, they generally do not. Instead, most parties choose an entity type for its default features and leave most of those features in place. For example, participants who feel comfortable with the idea of a board of directors are likely to choose the corporate form. They could instead choose an LLC and specify that it be governed by a board of directors, but that might add complexity without serving any useful purpose. One result is that most entities with many investors are corporations, and most entities with few are LLCs. All right. Now, again, all of this can be tricky. So you really have to follow along and you really have to pay close attention. Because, again, as I mentioned, the LLC is a legal entity. The LLC has two choices or two options. It can stay in its default status, all right, as a pass-through entity, or it could elect to be a S corporation or a C corporation. And if it chooses to be a S corporation, it's going to be the same as the default status, and all of the income is going to flow through to you, which is also a pass-through entity. The C corporation is a whole different ball game. That means it's a totally separate entity from itself, and that is the entity of choice from the LLC law boss. All right, let's keep going. Let's keep going. Just one moment. I hope you're standing right outside the door since you interrupted me, so I can see exactly what it is that you want. What? Now why you had to come in here to ask me that when you could have went up the stairs and looked? Come here, Janae. You went upstairs to look and see if she was at home. Is she up there? So what is asking me gonna do? Huh? No, I was doing some stuff and she interrupted me. But if she went up there to go look, and if she came back and said she not up there, what? Nah. And she been gone for a very, very long time. Now I seen a bunch of cars up at the school. She claimed she was being up at the school, but for what? I don't have a clue.